Swayam Prabha. Digital India. Educated India.
So, welcome to all the learners. We have started discussing on the provisions related to tariff, and in the last class we have discussed that how the whole subject on tariff has been distanced away from the government, and we have also learned that the approaches to determine tariff, the very terms and conditions for the determination of tariff has been evolving, and the whole idea is to make the tariff very competitive, so that the consumers will get benefited. Now, in this regard, we will now study that how the law, the Electricity Act, refers to the very determination of tariff, because in the last class we have discussed that what are the terms, rules, regulations which are what are the terms, conditions which has to be formulated by the appropriate commission for tariff determination, tariff fixation. Now, in today's session we will be studying that how this determination happens, what is the way to determine the tariff, and apart from determination of tariff by the appropriate commission, how it has been done by entering into a contract by the parties concerned. So, today in one session we will discuss this, and then there will be we will have and then later on we will also look into the scenario, we will look into the relevant provisions that how two contracted parties can enter into tariff fixation. And then there shall be an oversight responsibility of the commission. So, in this session we will study on tariff determination, what are the procedures which are being followed for the tariff determination, and then we will look at some of the case laws that how the court has responded to the issue of tariff determination. Now, when you look at the scheme of the act, you find that appropriate commission has been vested with the necessary authority to determine tariff, but then it has also been suggested that appropriate commission shall be guided by the terms and conditions laid down under section 61 of the act. So, when you look at the very scheme of section 62, it says that appropriate commission shall determine the tariff for supply of electricity by a generating company to a distribution licensee, and in case of shortage of supply of electricity, what the appropriate commission shall do is that shall try to come up with the maximum and minimum ceiling of tariff for sale or purchase of electricity in pursuance to that agreement which has already been taken place between the generating station and the procurer and the distribution licensee, and then that shall not be for more than a year, whatever appropriate commission decides. And the idea is that the parties concerned should not take undue advantage because of the shortage, and that is why the role of the appropriate commission has been devised, so that reasonable pricing is to be maintained in case of shortage of supply of electricity. So, regardless of the power purchase agreement entered between the generating units and the distribution licensee, maximum and minimum ceiling can be determined by the appropriate commission. And as I have been telling to you, and as the law also stresses on the consumer's interest, this provision is certainly a provision furthering the cause of the interest of the consumer. Apart from that, you also find that the appropriate commission is given the necessary authority to determine the tariff for transmission of electricity, for wheeling of electricity, and also for retail supply of electricity. Now, we have studied that under section 14 there can be a possibility of more than one licensee operating in distribution segment, and if we have more than one licensee, then section 62 suggests that in such kind of such situation of retail supply of electricity, what is needed, what is desirable, that the appropriate commission comes up with the maximum ceiling of tariff, so that any price lesser than that, any price lower than that can very well be negotiated by the parties concerned, by the generating units and by the such licensee. That is what it says. Now, for determining the tariff, section 62 further says that appropriate commission can very well ask the licensee or the generating company to furnish details, necessary details. What is the necessary detail here? This is all about knowing that what is the cost involved, what are the operation and maintenance cost involved. So, this is how the court, this is how the commission tries to find out that what shall be the kind of reasonable tariff, so that there is reasonable return to the generating units, reasonable return to the transmission licensee, reasonable return to the distribution licensee while fixing the tariff. That is what is very important, and that is the reason why this power is given to the appropriate commission to ask for the necessary details from the generating company and the licenses, because with that detail the appropriate commission would be in a position to understand that how reasonable profit can be ensured to the licensees or the generating units. Now, it also says that certainty is an important mantra for infusing the confidence in the players of the market, and that is why it says that the determination of tariff once done, it must not be changed unless and until there are issues involving the escalation of price on fuel. So, periodic adjustment is allowed only when there is a variation in fuel price, and that also there has to be a sort of objective parameter to be adopted for bringing that change in the tariff determination. Otherwise, there shall be no revision in the tariff determined in a financial year. That is what it says. So, tariff any attempt to relook at the tariff shall be done only when within a year, only when there is some issue with regard to the cost of fuel. Otherwise, that tariff should allow to continue at least for an year or so. Section 62 also talks about a kind of embargo on the generating companies, on the distribution licenses, that no undue preference shall be given to any set of consumer. We have discussed in detail about it while discussing about the interest of consumer under section 62 subsection 3. So, that is another important factor which has to be kept in mind by the appropriate commission for determining the tariff. And apart from that, the act also says, the section 62 also says that in order to arrive at, in order to identify that what shall be the reasonable pricing, it is expected that the licensee or the generating company will submit expected revenues and charges to the appropriate commission, so that accordingly the appropriate commission will find out, will try to look at that what is the expectation of revenue collection and how the pricing shall be done, so that that revenue collection is ensured to the generating company or the licensee. Now, when you look at the very exercise of tariff determination under section 62, legally speaking, if you take up the question that what is the nature of the very process of determining tariff, whether it falls within the ambit of judicial function or it falls within the ambit of legislative function. And this question is important for understanding the very procedure which the appropriate commission would be following for arriving at the tariff. If it is judicial, then proper hearing has to be given to all the concerned and then only decision has to be arrived. If it is legislative, then that is not required. So, looking at the scheme of section 62 1 subsection 1 read with section 61, it appears that tariff fixation exercise is a quasi legislative in nature. It is quasi legislative, it is something like where the law is being made. And why this becomes important? Because the procedure for determining the tariff warrants the objection or suggestion from the public, which is section 64, which we will discuss in a while. Now, how the appropriate commission shall go about it? Now, if we consider it as a quasi legislative function, then tariff notification unaccompanied by reason cannot be said to be fatal in law, cannot be said that principles of natural justice is not being followed, because already the necessary objections have been taken into account by the appropriate commission. So, it is not necessary for the appropriate commission to clearly spell out that why this tariff was determined. That is what is not needed if you consider it as quasi legislative. Had it been a judicial one, then such a requirement would have been needed. Now, what it says that once the formula to determine, once the proposal to determine tariff is being presented to the public, and if there are objections made by the public including consumer, then in such a situation appropriate commission is duty bound. Appropriate commission is having a bounden duty to disclose the reason about the tariff fixation formula. That is what is important. So, please look into this aspect, that if there are no objections laid down, if there are no objections submitted for tariff fixation, then in such a situation the appropriate commission can very well notify the tariff as per section 62 and there would be no fatality in such notification. But if objections are being laid down, if the public while looking at the proposal submits the objection, and if those objections are unattended, then in such situation the very exercise of tariff determination would be unsatisfactory, would fall flat, will not be considered as a something code to which will not be considered as something in accordance with the scheme of the act. So, that is what is important. And then further it says that as I say, that if tariff proposal is published and there is no objection to it, then absolutely fine, there is no question of disclosing the reason for such fixation, that is absolutely fine. That is what That is what is the essence of legislative act. Now, when you look at the overall formula, overall scheme of tariff determination under the Electricity Act, there are two ways suggested. One is under section 62, which talks about appropriate commission determining the tariff as per the regulation. Second one is based on competitive bidding under section 3, which we will discuss in the next session. So, what is important that under section 62, the methodology which is being adopted for fixing the tariff is based on cost plus formula. So, somewhere in the core of the approach is that what is being invested and how it is to be ensured that there is an reasonable return to the investment made. And I have already discussed in detail about the cost methodology, the normative approach which is being influencing the methodology in the last session. Now, why this cost plus and why this kind of approach to be followed by the appropriate commission? Because of the paradigm shift which has been introduced under the Electricity Act. What is that? That from single buyer model we have adopted a multi buyer model. So, therefore, the Act does not prescribe any particular mode of procurement of power. Act does not say that how the procurer shall procure the power. It could be in the form of memorandum of understanding under section 62, where appropriate commission suggests the tariff, or it could be in the form of bidding as it is conceived under section 63. Now, in MOU, in memorandum of understanding, it has been said that this is a sort of situation where you have a bilateral contract between the generator and the licensee, and in that process the appropriate commission has been asked to suggest the tariff as per the guidelines laid down under 61. So, power purchase through memorandum of understanding, when you look at it, what it says that tariff of the power to be procured is to be approved and determined by the respective commission. So, once there is a power, once there is memorandum of understanding between the parties, generating units and the licensee, and then in that situation they determine also that what shall be the tariff, but then that must get the approval and that must be determined by the commission as per section 62. So, look at it, here it is not happening on the basis of bidding, here it is happening on the basis of bilateral agreement where negotiated rates are being finalized. But then for finalizing that negotiated rates, the law says, section 62 categorically says that it has to be in compliance with the terms and conditions set under section 61. So, that is how section 79 or section 86 comes into play, where the commissions determine the tariff. Now, as I said that appropriate commission while determining the tariff has been categorically refrained from showing any kind of preference to consumers. But then the second part of section 62(3) presents a situation which commission can consider for having a differential rate. I have already discussed or touched upon this while talking about consumers' interest. So, what are the factors which are taken into account if you look at it? Consumers' load factor, power factor, voltage, total consumption of electricity during any specified period, or the time at which the supply is required, or the geographical position of any area, the nature of supply and the purpose for which the supply is required. Now, the last two conditions, when you look at the nature of supply and the purpose for which the supply is required, these conditions confer wide range of choices with the appropriate commission to have differential tariff for different set of consumers, because purpose for which the supply is required can very well be justified considering the activity, the nature of activity, considering the identity of the consumer. So, very wide choice which has been given to the appropriate commission under section 62 subsection 3. But then what is important to take note of, that such differentiation must be done with utmost care and greatest circumscription. Why? Because it is based on what is important to be taken note of is that whether the very criteria of intelligible differentia is being followed or not. The group which has been considered and the group which has been left out, is there any reason behind the same or not? Law students should appreciate by connecting it with test of reasonable classification evolved under Article 14 of the Constitution. So, section 62(3), while conferring this power on the appropriate commission, very well in a way imposes a sort of procedural limitation and substantive limitation, that yes, you can very well look into the purpose, but then there has to be a proper nexus, there has to be a kind of connection between what you intend to do and the way you have identified the beneficiary, whether there is any connection or not. Now, section 64 talks about the procedure, that what procedure shall be followed by the appropriate commission for determining the tariff order. Now, what it says, that there shall be an application made by the generating company or by the licensee, and then the same has to be notified, same has to be published in the newspaper, and the idea behind publishing the petition is to invite objections or suggestions, and once the objection and suggestion is been invited, appropriate commission has been given 120 days to look into those objections and suggestions and then decide accordingly. Now, as we know that electricity sector is heavily regulated, it is a regulated activity, and therefore, these kind of provisions which allow public to participate, these kind of provisions play significant role in shaping the power and function of the appropriate commission, because these are the steps where appropriate commission be bound to satisfy the objections or reasons which are submitted by the public. Otherwise, these regulatory bodies are not directly accountable to any elected representative, they are independent, autonomous. So, it is not very difficult to imagine that if through this kind of provisions they are not made accountable, there is a possibility that they may not discharge the function in a very objective manner, in a very in a very approach which aligns with the scheme of the Act. It says that once the objection is being attended, suggestions are being taken note of, appropriate commission can very well issue the tariff order, or it can reject the application, but then while rejecting the application, the law categorically says that reasons must be recorded for such rejection. And further it says that if the application is rejected, then the applicant must be given an opportunity to present his case. So, again this kind of provisions as a law student we need to understand, important for making the functioning of the regulatory bodies transparent, accountable, and at the same time ensuring the fulfillment of the spirit of the law. So, that is what is the procedure which is there under section 64. Now, 64 also raises the question that is there any prerequisite on the part of the appropriate commission to give the personal hearing before notifying the tariff. Now, when you look at the structuring of section 64(3), what it says? It says that you invite the objection and you have two choices. The appropriate commission has two choices. One choice is the choice of issuing the tariff order, and the second one is to reject the application, and while rejecting the application, then procedural requirement is to be followed, that reason has to be given and then hearing has to be given. So, the closer reading of the scheme says that no need to give personal hearing, because anyway personal hearing is statutorily assured in case of rejection of the application, and that is why it is being said or suggested that what is important, that the procedural compliance must be there in case of rejection. And how this understanding is coming? This understanding is coming from this very reading of section 62 with section 64, that tariff fixation is a legislative function. This is something which has to be read akin to, this is something which has to be read very similar to the law making exercise undertaken by the legislative body. And further it says that if at any point of time it has been found that fixation of tariff has not taken place in accordance with section 61, in accordance with the terms and conditions laid down under section 61, it is always open for the aggrieved party to file an appeal under section 111. So, that is what is the scheme of the act which says. Further it says that generally it has been said that interstate supply, transmission or billing of electricity should be a responsibility of the central commission, Central Electricity Regulatory Commission, but 64(4) subsection 5 creates a sort of exception, where it says that a state commission can very well determine the tariff when the territories of two states are involved. Two states are involved, particularly the section categorically the section talks about two states. So, if it happens to be more than two states, then again the necessary jurisdiction falls with the Central Electricity Regulatory Commission. So, state commission can determine the tariff having jurisdiction in respect of the licensee who intends to distribute and make payment for electricity. And why this exception, how you are reading this exception? Because when you read section 64 subsection 5, it starts with non-obstinate clause, and we have been reading as a law student that non-obstinate clause has this feature that it overrides. So, otherwise what is a jurisdiction, what is there with the Central Electricity Regulatory Commission under 64(5), an exception is created, and it has been suggested that the state commission can very well also determine the tariff, but then it must be a situation where that state commission is having a jurisdiction in respect of the licensee who intends to distribute. Section 49 I am highlighting just to bring this point that how power purchase agreement is categorically acknowledged under the scheme of the law. it gives a choice to the consumer who has the open access permission to enter into a power purchase agreement with the generating companies and on such terms and conditions including the tariff of power as agreed by both the parties. So, parties can agree on terms and condition, but please take note, when parties can agree on terms and condition, obviously it must be subject to section 61, it must be subject to section 62, that generally the kind of guidelines which are being laid down. Let me just highlight this one this case. This is Messrs Central Coalfield Limited versus Jharkhand Electricity Regulatory Commission. This is an interesting case decided by the tribunal where this Central Coalfield Limited invited DLF Power Limited to set up a captive power plant, and there was some negotiation happened with regard to tariff between Central Coalfield Limited and DLF Power Plant. The DLF was said to set up a power plant on the model of build, operate and own, and DLF set up a plan, start supplying electricity to Central Coalfield. It was a captive power plant. It was exclusively supplying electricity to Central Coalfield, and then there was some issues was raised with regard to tariff fixation. Both the parties, they approached the regulatory commission. They said that that there is some dispute and kindly resolve it. Jharkhand Electricity Regulatory Commission attempted to resolve the same, and when Jharkhand Electricity Commission suggested an formula, then Central Coalfields again raised the point that because the tariff fixation was not done as per section 62, there is the regulatory commission does not have any jurisdiction, and thus there cannot be any appeal against the decision of the regulatory commission before the appellate tribunal. Now, the tribunal looked into the scheme of the law, and tribunal says that section 62 comes into play only when the tariff determination is done between the between the generating company and the licensee. In this case, DLF Power is not a licensee. There is no license issued to DLF Power under section 12. It is just generating power, and that power is exclusively meant for Central Coalfield Limited, and therefore, whatever tariff has been fixed is all about mutual agreement, mutual understanding between both the parties, and there is no question of bringing in, there is no question of invoking section 62 of the Act. And further, the tribunal also said that whatever regulatory commission has done in pursuant to the arbitration clause agreed between the parties here, and it has done as an expert body, and on this premise the tribunal categorically said that because tariff fixation was not done as per the scheme of section 62, there is no question of considering the appeal against the decision of the regulatory commission under section 111. So, the court clarified that in what context, in what situation section 62 get attracts, and the order of the appropriate commission becomes appealable before the appellate tribunal. This is another case where two different tariff was being fixed by the Kerala Electricity Regulatory Commission. In Kerala State Electricity Board versus Principal Sir Syed Institute for Technical Institute Studies, Supreme Court was asked to look into this question, that can there be two different tariff structure, one for the government run educational institutions or government aided educational institution, and another is for self financing educational institution. Now, the question was raised that both of them, they are imparting education, they are not into profiteering, and therefore there cannot be any different tariff fixation. The regulatory commission said that different tariff formulation is very much possible, it is permitted because of the very fact that the 64 subsection 3 says purpose for which supply of electricity is being made. So, that expression purpose gives the necessary discretion to the regulatory commission, and in this case regulatory commission said that we have very rightly distinguished between self financing and government aided or government run, because in government run generally students from modest background they come, and therefore that has to be seen more as kind of responsibility of the state to engage into welfare activities, which is not the case with the private education institution, and private education institution can very well be seen as commercial activity, and on that premise the differential pricing was suggested. The Supreme Court agreed with this distinction. Supreme Court said as long as the difference is based on intelligible ground, necessary statutory approval is to be examined. Necessary statutory approval is to be understood in the light of the scheme of section 62 subsection 3. So, this is a good case to understand that how regulatory commission can very well design, regulatory commission can very well come with the two different tariff. It could be also for preferring one set of industry, it could be also for preferring the government run initiatives in contrast with the private initiatives. So, this is all on tariff determination under section 62. Thank you very much.